Welcome to today's Asian Law Centre Brown Bag session. My name is Sarah Biddulph. I'm the Director of the Asian Law Centre. First, I'd like to acknowledge that we are having this meeting on the unceded lands of the Wurundjeri people of the Kulin Nation, and I stand in solidarity with their ongoing struggle for justice. So today's seminar is our dear friend and great colleague, Dr. Ben Hopper. When I was reading your CV, I noticed that you had omitted your PhD.
That was, yeah,
the bio.
an oversight.
An oversight. So let me just correct that oversight. Ben has recently graduated with his PhD from the University of Melbourne, and I had the great pleasure of being one of his thesis supervisors. And so that means that today I sort of feel like an insider in this talk, having read the thesis a couple of times, 75,000 times. No. And so I know exactly how brilliant this work is and how interesting. So Ben's talking today about a new explanation of Chinese patenting phenomena with a focus on patenting traditional knowledge. And this talks about traditional medical knowledge, focuses on Guizhou and the, I said Guangzhou and I meant Guizhou.
Yeah.
The focuses on the minority groups who are traditional medical knowledge holders, primarily the Miao people, but yeah, I think you managed to gather a few other people as well. And Ben has a really interesting argument about patent grip, which is quite original and brilliantly demonstrated throughout his work. And rather than summarise it, I'll let you talk about it.
Thanks, Sarah.
Thank you, Ben.
And I'd also like to acknowledge we're meeting on the lands of the Wurundjeri people of the Kulin Nation. Pay my respects to elders past, present and emerging, and extend that respect to any Aboriginal and Torres Strait Islanders here with us today. Thank you, Sarah, one of my PhD thesis supervisors. Also, thank you to Graham Austin and Megan Richardson, my other supervisors who aren't here. And thank you to Sue Finch of the Melbourne Statistical Consulting Platform, who helped me a lot with the statistical analyses in my thesis. And of course, a big thank you to Catherine Taylor and the Asian Law Centre and IPRIA, who have set up and organised this event. So without any further ado, let me begin. It'll be quite a journey for us today, so I hope one that we all enjoy and find rewarding. So I want to start by giving an overview of China's patent law, the law on paper, and then look at the patent boom, and then set out what I say my claim is, which is briefly that markets activate patent laws on the ground, and then introduce you to the case study that I built on the patenting of traditional medicines in China's southwestern, relatively poor Guizhou province, set out my key findings and then my conclusion. And just to note, this isn't quite just a presentation of my thesis. Or what I'm trying to do today is use my thesis to shed light on the patent boom in China, really to make it something of greater interest to an Asian Law Centre audience, as opposed to like a patent law or patent theory audience. So yeah, China's patent laws. So I want to start by looking at the laws on paper, China's patent law, and I'm going to give a little bit of its history, and I want to see how that patent law has become more capitalistic and has given greater protection in terms of economic protection to patents, at least on paper. So before then turning to what Eugen Ehrlich calls the living law, the patent law in the real world. Is this going to work now? Is that me doing it or you? Oh yeah, magic. There's some debate about whether there were patent laws existing in dynastic China, but I think the majority view, including of renowned IP scholar Zheng Chengse, is that there was no modern patent laws. However, in the late Qing dynasty, there were attempts to introduce a modern patent law. So during the Taiping Heavenly Kingdom rebellion and movement, one of its leaders, Hung Gan, wrote a new treatise on aids to administration, which suggested the introduction of patent laws, but that movement fell away. Although importantly, both the Nationalist Party and I think the Communist Party traced their roots, or in part at least, to that movement. Subsequently, Emperor Guizhou tried to introduce a couple of pieces of legislation that would set out patent laws, the 1889 Charter and an 1898 regulation, but that charter and those regulations never really went anywhere. So it's not until the Republic of China period in 1912 when we get something of a lasting patent law, the interim charter, but not many patents are awarded, definitely not more than 1,000 patents awarded under that charter. And then in 1944, there's the patent law of the Republic of China, which, due to the civil war between the nationalists, Kuomintang, and the communist parties, never became enacted on the mainland, but became the law of Taiwan. 75 years ago, we're in the 75th anniversary of the People's Republic of China, the communists won the civil war, as everyone in this room will know. And the PRC initially adopted, influenced by the Soviets, a dual track system of protecting invention. So that means that you had one track which was like a traditional patent track. You'd apply for a patent and there'd be exclusive rights associated with it. And then there was a inventor certificate track, which wasn't like an exclusive monopoly. It was more a reward or a recognition, generally calculated by reference to the savings in production attributable to that invention. And then in 1954, you had provisional regulations come in, which effectively got rid of the patent track. And so the only legal recognition for inventors was the inventor certificate track. And then under the 1963 Invention Award regulations, it was made clear no patents, and also it was made clear that all inventions belong to the state. 1978, Deng Xiaoping ascends, outmaneuvering Hua Guofeng, becomes the leader within China, ushers in an open door policy. There is very heated debate about whether or not to introduce a modern patent law. So opponents and detractors say we shouldn't be allowing control of important technology to sit in the hands of a few. Proponents say it will assist with capital accumulation, which we need. It will assist with technology transfer, which we need. It was such a big debate, in fact, that it took no less a personage than Deng Xiaoping to step in favour of having the patent law, and it was introduced in 1984. It's not quite a patent law would be found in Australia at the time, or the United States, or Europe at the time. It sort of straddled a socialist economy and a capitalising or marketising economy. So it took into account Marxist politics and economics and the specific conditions of China. So, for example, the law's objects were to protect the patent rights of inventions and meet the needs of socialist modernisation, the four modernisations of the time. Service inventions were clearly stated to belong to the work unit. And in the mid-1980s, the work unit who employed you was not only your employer, it was also a source of welfare, a source of housing. So basically, it would be very difficult for anyone to come up with an invention outside of the work unit that wouldn't belong to the work unit. So there was also a state plan involved under which the state could quite readily, compulsorily license patents. The Director General of the Chinese Patent Office in 1985 in a short article published in the Beijing Review, reproduced here, wrote that the basic theory behind the patent law was formed by taking into consideration Marxist politics and economics and the conditions of socialist China. And he also wrote that patent laws in capitalist countries, because they're based on private ownership, emphasize exclusiveness and monopoly of patent rights, but the Chinese patent law, based on a diversified socialist economy, sets forth different provisions for patent rights according to different cases. Then we have Huang Kunyi shown on the screen. He, in this short article on the unique features of Chinese patent law, disavowed a natural rights theory of patent law and a contract or disclosure theory of patent law on the basis that they, quote, follow the ideas of bourgeois law. And he set out a theory of patent law based on more a socialised mental labour conception of the law. And he noted, and I think this is important, so I've quoted it on the screen, and I think this reflects really deep study that had been undertaken in developing China's patent law. He noted that because production and exchange of commodities continue to exist under socialism, they should be broadened and developed. The patent system, born towards the end of the feudal age, developed in capitalist society and still flourishing under socialism, will help towards that end. And I want to reflect on this statement for a moment because I think it is important. It suggests an acceptance of commodity exchange in socialist China. It also suggests, as most mainstream patent economists will say, that patents having a patent law will facilitate market exchange. But as we will see, my claim or my thesis is a variation on that claim. After 1984, we had a first major revision of the patent law in 1992 to reflect a China-US Memorandum of Understanding. And then in 2000, a second major revision to bring China's patent law into compliance with the trade-related aspects of intellectual property agreement. One of the agreements China's laws had to be compliant with in order for China to accede to the WTO, which it did in 2001. And we had a third major revision in 2008, which was enacted in part to implement China's national intellectual property strategy, which emphasised obtaining of patents in core areas of technology, specifically listing medicines. And that's the law on paper that applied during my case study, because I did my case study in 2019, before the latest revision came into effect in 2020. And we can see that we've come quite a way from the original patent law in terms of having a more capitalistic understanding of the way patents work. So, for example, the object now is no longer to meet the needs of socialist modernisation, but rather to advance economic and social development. And whereas previously service inventions, anything that you came up with using the resources of your work unit or doing work for the work unit belonged to the work unit, now you could actually negotiate with your work unit a separate owner entitlement to apply for the patent right. And the state plan for licensing also was heavily diluted compared with what it had been previously. Just a couple of points without getting too deeply into the doctrine, but I just wanted to note that some points about the way that validity of patents and infringement of patents are assessed in China. Nothing here would be surprising to a patent practitioner in Australia or the US or anywhere in the world. So the key criteria of validity is that we have to have an invention, it must be novel, it must be inventive, it must be practically applicable, and importantly under Section 26 of the patent law, it must be fully. You'll see why I say that's important once I get into the details of my case study. It must be fully disclosed. And on infringement, the Patent Act gives the patentee the exclusive right to exploit the patent, including to make and sell the patented product. China adopts a doctrine of equivalence in order to determine the scope of the claims, in order to determine infringement, and has set up, there are many IP courts now, or there are intermediate courts where, and they're all shown in that image on the screen, where you go in the first instance to resolve a patent dispute. Okay, so now that we've got an understanding of the law on paper, I want to get into the patent boom. This boom, which has so engaged China watchers and patent scholars, including maybe because if you speak to the general sort of lay person on the street, your Uber driver, your taxi driver, I know that I do when I say to them, hey, I study patent law in China, they'll be, oh, what, China has IP laws? Or, China, you know, that's sort of a general view. So I think to a large extent outside our cloistered kind of ivory tower here in academia, China's still very much viewed through a prism of it being a land of counterfeit. But to the contrary, IP, registered IP rights have gone, to put it bluntly, gangbusters in China. So this graph on the screen shows the very significant rise in, so these are, this blue line is, so Chinese resident patent applications. So people in China applying to the Chinese Patent Office for patents and invention patents in particular. So we can see that in 2005 they start to take off. In 2009, here, about a year after the introduction of the third major revision to the patent law, the one enforced during my case study, there was some 230,000 resident patent applications, and then up in 2019, the year of my case study, there were over 1.2 million resident patent applications. It's quite a phenomenon. Mainly economists have been interested in this, less legal scholars have been interested in what's going on here. And they've looked for various variables to work out, okay, how do we explain this growth? What's going on? Why have we got 230,000 patent applications in 2009 and 10 years later in 2019, over 1.2 million resident patent applications? The usual explanatory variables are put up on the screen. I just want to add a prefatory note that I'm not dismissing, I don't dismiss these variables. My claim is that my thesis and what I say it shows is indicates a factor that needs to be weighed into the mix in order to understand and explain the patenting phenomenon. It's sort of a necessary but not sufficient condition that I think the usual variables miss. So R&D intensification, well, that makes sense. You know, the idea is the more that you're investing in research and development, the more likely it is you're going to come up with inventions. If you come up with inventions, it's more likely you're going to get a patent. So we should look at R&D intensification. And indeed, our patent economists, Albert Hu and Gary Jefferson, did that. And they estimated that R&D intensity in their sample contributed explained about 24% of the patent growth. Foreign direct investment is another factor. The more companies from overseas are investing and bringing technology transfer into China, the more opportunities there are to imitate and build on what they're seeing, and there's more competition, so a greater drive to innovate around and then possibly patent what is being brought in through FDI. There is a phenomenon of patent subsidies in China, which I think gets a little bit overblown in the discourse, particularly the economics literature. So these are dispensed on a province by province basis, so there's not a uniform subsidy system applying throughout China, and they are subsidies that help applicants with the fees that you pay as part of applying for and possibly prosecuting your patent application to acceptance. There are various studies saying they make a significant impact. There's a quite recent study from 2019, I think, showing that the patent subsidies didn't have a statistically significant impact on applications for patent inventions. And then lastly, but not leastly, as we saw in my brief survey of the history of China's patent laws, they've strengthened the value of patents, at least on paper. And so that's another factor that analysts have looked at to explain why people are getting patents. They've become more valuable. Okay, that means some more likely to go apply for one. Most of these studies rely on macroeconomics, so national level data, generally at the level of the firm, not the level of the individual. And most of them are based on a few assumptions about the way people will react to patent laws. People are utility maximizing. We seek to maximize our own utility. We are rational entrepreneurs. What the utility that we're seeking to maximize is monetary, is profit. And also we have this way of viewing knowledge, a particular way of viewing knowledge that sees a new invention or a new bit of knowledge as a unit, as a unit that can be packaged and made into a piece of property. And I think some of those assumptions, and I'm not trying to set up a straw man here because I think it would be very easy to do that, but I think some of those assumptions do come undone when we get on the ground and we see how people are using and thinking about patent law or the patent system in the real world. So now we've got an understanding of the patent law on paper and some of the debate over the patenting phenomenon. Let's get into my claim and my case study and see what light that might shed on this patent boom. So just to reiterate, all the factors we've considered now I think are relevant and important, but behind these remarkable patenting figures, I suggest something more, even more remarkable may have been going on, and that is this, that with an more intensely commodity exchanging economy that has developed in China, there's been a shift in the way that people view knowledge. There's been an epistemological shift, such that so that while in 1985 China's Director General of the Patent Office, Huang Kunyi, intoned that China's patent law is premised on a diversified socialist economy, he did recognise that the patent system helps towards the end of exchange of commodities. But what I want to suggest today is perhaps the increase in patenting has to do in significant part with a more intensely exchanging commodity exchanging economy, such as the exchange of commodities. This is what's helping the patent system rather than the other way around. There are many indications that China has become a more capitalistic economy, although it's not linear, it vacillates. So for example, the World Inequality database shows a spectacular rise of private wealth since the 1980s to today. So in 1980, about 70% of national wealth in China was public and about 23% private. By 2022, those figures had almost reversed and about 30% of national wealth in China was public and 70% of wealth was private. This is a picture of Evgeny Bronislavovich Pashukanis. He's an early 20th century Soviet scholar. What has he got to do with anything? The rise of commodity exchange in a mixed economy, which is what China is often called, a mixed economy, I think does lead one to the work of this one-time doyen of Soviet legal scholarship before Stalin had him executed, Evgeny Pashukanis, who developed a commodity exchange theory of law. And he did it at a time when Soviet Russia in 1921 to 1924 was itself in the early stages of a mixed economy, introducing its new economic policy. So I think given where he was positioned and given the theory he developed and what it's trying to explain, I think this can help us to understand what's going on with patents, with the patent phenomenon in China. His theory stresses the importance of social relations in order to understand legal relations and suggests that under conditions of commodity exchange, we as individuals become nodes or mathematical points in a system of exchange of commodities. I become someone through whom commodities exchange by buying and selling goods, including by buying and selling my knowledge, so that we become under intensely commodity exchange in conditions, abstract owners of commodities raised to the heavens, abstract owners of commodities raised to the heavens. That's one of his quotes. So if we apply his theory to patent law, I think we can say the following. As we become more ensconced within market relations, we exist more as individual commodity owners interacting with other commodity owners, exchanging things on markets. And the more that things are exchanged on markets, the more they come to represent the value of other commodities, exchange value in Marxist terms, and the less they come to be valued for the labour or the use that I could put to them, their use value. And as the reach of markets expands to cover ever more categories of things, and we come to view our labour and our knowledge increasingly in terms of this exchange value, so too do we come to see knowledge as exchangeable on a market. And when that happens, patent law becomes important to facilitate the exchange of intellectual things come knowledge commodities, including inventions and goods like a packet of medicine, embodying an invention, like a new medical formula. So for example, my medicine embodying my invention, my inventive formula, when ceases to be, through the introduction of patent laws, it ceases to be unstable, precarious, purely factual property, which may at any moment be contested and have to be defended weapon in hand. It's transformed into an absolute fixed right, which follows the object wherever chance may take it, protected all over the world by laws, police, and law courts. So drawing on Pashkanis and a few other scholars, I developed this thesis of patent grip, which is twofold. One prong is that the more market-oriented a person is, the greater the grip that patent law has on that person. That is, the more likely the person is to use and obey patent laws. And two, that grip is enhanced by that person's closeness with the state. After all, patents are granted through a system of registration with the state, and you need to have at least some minimum level of trust in order to disclose what might otherwise be a valuable secret invention to the state. So in order to prove this hypothesis, I thought I needed a suitable case study. And one presented itself in the form of the emergence of a market for traditional medicines in Guizhou, China. Well, why is this a suitable case study? Well, first, as I just said, there's a market, right? And I'm interested in what markets do to the grip of patent laws. Two, the market has developed pretty recently, since the 1980s and especially since the early 2000s, suggesting that there's probably going to be people who are differently market-oriented, different levels of marketisation. And three, the introduction of patent laws is also relatively recent. The first modern patent law only 1984, and in its more capitalistic version, 2008. And so that should mean that I would be able to find people who are differing in terms of the extent of their patent grip. And fourthly, and importantly, the case study looks at the patenting of traditional medical knowledge, which is, if not the antithesis of invention, has been described as the other of an invention. Right? We don't normally think of traditional medical practitioners as people who get patents over their traditional medicines. And in an important 2007 article, IP scholar Madhavi Sundar talks about traditional knowledge as being viewed as the raw stuff from which inventions are made, but not inventions per se. So the conceit of, or part of the conceit of this case study is that if there's evidence of something that we normally wouldn't think of as being patentable, i.e. traditional medical knowledge being brought into a patent system, then that's by people who are more marketised, then that's pretty good evidence in support of the hypothesis. So, I said a market had recently developed for traditional medicines and traditional medicines in China and in Guizhou. So I go into some detail in my thesis. I'm at pains to make good that point, but here I just give a little bit of data to make good that point. So we can see the number of private firms, which tend to be more market-oriented compared with state-owned enterprises. Their number and proportion within China, that is, these are pharmaceutical manufacturing firms, has increased. So, for example, I'm trying to read my text. So in 2011, there were 2,436. I think that's right. But then 10 years later, that had grown to 3,670. So more, and also a significantly bigger proportion of the total pharmaceutical manufacturers in China. So suggesting the blue ones are the the state-holding enterprises. The green ones are foreign-funded firms, which arguably also relevant. But so I don't have that granular level of data for Guizhou, but I do have data showing that there's been an overall increase in the number of pharmaceutical manufacturers in Guizhou, which does suggest market growth and competition growth. So we can see there was quite a growth between 2012 and 2017, and then a leveling off in 2018 and a slight dip in 2019. Along with this, there's been a lot of patents applied for in both China, nationally, and Guizhou. The patents are very similar at the provincial level of Guizhou and at the national level of China, which is interesting, not least because among a lot of TMK is subject to customary practices of being kept secret and handed down from generation to generation. So, so notwithstanding that, we can see that this patent boom also has happened in respect of TMK-derived inventions. So, how did I get the data? So, all right, so now I've tried to establish that there was a market for medicines, including nutritional medicines. Now, how do I get my data to try and test the hypothesis I explained earlier? So most of my data I got from fieldwork. So I conducted a survey amongst TMK practitioners in Guizhou in the second half of 2019. I even was involved in a 3-hour shamanic ritual in a Miao village, although that never made it into the thesis, Sarah. And we can see, you know, Guizhou is a gorgeous part of the world. These are just some happy snaps that I thought now might be a nice time for some levity. It's an isolated province consisting of mountainous karst geography in the southwestern China on the Yangui Plateau, between the fertile Sichuan Basin and the low plains of the adjacent province of Guangxi. And those living in the mountainous areas of Guizhou, including in particular the Miao ethnic minority, who Sarah mentioned, most of the TMK practitioners I spoke to were of that group, have been associated with the wild or the raw. Guizhou is also highly biodiverse, with nearly 4,000 different species of plants. So, all right, so back to my data. So for my survey, I wanted to obtain measures of individual TMK practitioners' extent of marketisation, their extent of patent grip, and get data on other intervening variables so I could test the strength, if any, of the correlation or association between an individual's marketisation and patent grip. Does their patent grip go up with marketisation, or does it go down, which would be against the hypothesis, or is there no correlation? So I managed to speak with 53 TMK practitioners, mostly Miao, but I also spoke to other ethnic minorities and also to Han TMK practitioners. The reason for there being so many Miao is that I originally intended to only talk to Miao and just have it quite a confined, I guess, neat case study, but I got worried that I wouldn't. It's very hard to find respondents because they're quite a specific category of respondents. So I thought, well, anyone I can speak to, I'll speak to. And I don't think that makes a difference in terms of my conclusions, the fact that there are Miao and also non-Miao in the sample. But if you go into the weeds of my thesis, you'll see I do the tests for both Miao and the whole group just to check. And I find no significant difference there. Okay, so they're the people I surveyed. So I developed, as I said, I wanted to get an understanding of the extent of patent grip. So for that purpose, I developed an index based on 9 dichotomous variables across the domains of the knowledge of patents, heard of patents or not. So dichotomous, yes, no, dichotomous binary variables. Use, so the extent they either have used patents or have been a license, or have licensed patents, or inspect patents, inspect the patent register. Their attitude, So would they get a patent? Do they think the patent good? And fourthly and lastly, obedience. Do they obey patent law or not? And that was a pretty simple question, just asking if you saw a patent that had a traditional medicine you'd like to use, would you use it? If they said yes, low obedience. If they said something else, like no, I'd first try and seek a license, then higher patent obedience. To get an understanding of their marketisation, I developed a marketisation index based on 3, again, dichotomous variables. How long they've spent buying medical goods on a market as opposed to gathering it for themselves, 0 years or 1 or more years. How long they'd spent selling medical goods on a market as opposed to just prescribing it to patients without or selling it. And where did they get the medical goods? Did they go to a market to buy it? Did they get it through formal channels? Or did they go, for example, to the mountains where a few practitioners took me and showed me the herbs that they gathered for their formulas? Okay, so now with these measures in hand, I tested my hypothesis, my key hypothesis, which is the more market-oriented a person is, the greater the grip that patent law has on that person. And so to test that, I examined the correlation between the marketisation index and the patent grip index, and I also then looked at the influence of potentially confounding or intervening variables. You'll recall I also had this second or sub-hypothesis, which is that patent grip's enhanced by a person's closeness with the state. In the interest of time, I won't go into this one in too much detail, but shortly, that was tested by constructing a political influence index comprised of 2 variables. Were they a member of the Communist Party of China or not? Were they employed by a state entity or not? So, onto my key findings. Lo and behold, I found a statistically significant, so here we have p-value of 0.002, significant, and pretty strong correlation of 0.495 between patent grip, the overall patent grip index, and the marketisation index. So 0.495 is doesn't explain everything, but it's a pretty, for the social sciences, it's a pretty strong correlation. And then with the sub-indexes of patent grip, I also found statistically significant correlations using a Spearman's row correlation, which was suitable for my data. On the second, or the sub-hypothesis, I didn't find a statistically significant correlation. Here it's above the level of 0.05, which I set my level of significance at. But, you know, it's still got a magnitude of 0.27 and it's positive. So that finding is still consistent with the sub-hypothesis, but not strong enough to allow me to reject the null hypothesis of no correlation. Possibly with a larger data set than the 38 respondents from whom I got relevant data, I'd be able to come to a more definitive conclusion on that. So I mentioned that I considered intervening variables. They're listed on the screen. So gender, I didn't find any correlations between patent grip and gender, nor with age. I did find statistically significant correlations between patent grip and formal education, that is education in a school as opposed to informal TMK training. Some quite strong correlations between income and patent use, and one correlation between patent knowledge and inventiveness, which I got data on by asking whether or not the respondent made new medicines or not, or whether they just prescribed what they had learned from their master or their instructor. To get a little bit more certainty about the strength of the correlation, I used partial correlations to control for other variables. So a partial correlation tests whether a correlation between 2 variables, X and Y, still holds after you account for the influence of a third variable, Z. And I found that the correlations between marketisation and patent grip indexes remained statistically significant after controlling for political influence. So after controlling for political influence, the correlation was 0.492. After controlling for ancestral influence, it was 0.432. After controlling for education, it was still significant after controlling for income, and still significant after controlling for inventiveness. So from all of that, I felt comfortable rejecting my null hypothesis of no correlation between marketisation and patent grip and saying, yeah, there's a correlation, a statistically significant correlation there. And so the patterns in my data can be neatly illustrated with some line graph representations I made. So these are divided my sample into three: people with high patent grip, people with medium patent grip, medium patent grip, and people with low patent grip. And broadly, we can see that people with high patent grip have a higher marketisation index. People with medium patent grip still have reasonably high, but a relatively lower marketisation index. And people with low patent grip have a relatively quite a bit lower marketisation index. And we can also see sort of, not quite a holograph, but a representation of where those groups fall in relation to the other relevant measures. So overall, the quantitative analysis broadly supported the thesis. And I also engaged in qualitative analysis, where I found social processes by which medicines become viewed as commodities and then made subject or perceived as being suitable for being made subject to China's patent regime. So in traditional medicine markets, for example, I observed processes of, to use Pierre Bourdieu's terms, mimesis and imitation, whereby the market itself served to quasi-educate TMK practitioners to think of traditional medicines not as raw herbs, but as products. And the less marketised and low patent grip respondents tended to engage in the sale of raw herbs as herbs. They didn't package them in a sort of a product sense. So for example, one respondent with low patent grip told me his formulas were valuable secret knowledge, and he couldn't sell them he would never think or dream of selling them to anyone. But among the higher and medium patent grip practitioners, we do see the herbs now packaged as products. And I suggest this is an imitation of what's going on with patented, major pharmaceutical company products, because I tended to observe this packaging at markets that were also very close to retail pharmacies, like Chemist Warehouse, Watson's, for example. Yeah. And we can see here, we've got up top, that's a traditional market store where the TMK practitioner has packaged their medicines in these products with markings quite similar to the products you would find in a retail pharmacy. So a striking example of this imitative practice is one older TMK practitioner I spoke to, who didn't charge money for his work with patients until very recently, after he was taken to the major commercial hub of Shenzhen in the southeast of China. In his own words, he said to me, "I've practiced meow medicine since I was 18 years old. I gave my medicines to patients for free. The patient in return would do something like treat me to a meal. Only in 2017 did I start charging patients money, just a little, because then I started paying for money for herbs from villages. But most medicines that I gather and make myself, I don't charge for them." Then another meow physician took me to Shenzhen last year, so that's 2018. And when I returned home, I began to charge money regularly. I'm getting older and I need to make a living. When I went to Shenzhen, I learned that even if you don't want to charge a patient money, they give you the money anyway. As we said, here we see the trappings of a sort of a quote unquote modern pharma product sold in a retail pharmacy. And here we see someone, a TMK practitioner, I suggest, imitating that to make it look more like a product. And these trappings, these marks and patents that people get, turn these TMK products, I suggest, to quote Toshikanis' words I quoted earlier on, they turned them from unstable, precarious property into objects having absolute fixed rights that follow the object wherever chance may take it, protected by law, police and law courts. I'm quite certain that this product from a retail pharmacy is protected by a patent, an extract of which is shown on the screen, a patent for this active energy oil formula. And patent notes, as many of these patents for Meow traditional medicines note, that it was based on research of Meow medicines in this one in Guizhou. But I hear you ask, as we get to the very end of my lecture, patent laws, as I said earlier, require the full disclosure of inventions. And as I also said, we have a customary practice amongst TMK practitioners that you don't reveal the secrets of these ancestral formulas. So how can these apparently contrary dictates coexist? Well, the TMK practitioners I spoke to, and this was common, they reconciled these dictates by, if they were a patentee, not including the core ingredients of their formula in the patent application, or if they were not a patentee but were open to get a patent, by saying, I would list certain ingredients, but the core ingredients I wouldn't list. You know, for example, a buoy practitioner who had no patent said to me, if I were to get a patent, I would only reveal some but not all the ingredients of my ancestral formula. If someone buys a patent from me, then I will tell that person all the ingredients. So the key function served by TMK patents for these medium and higher patent grip TMK practitioners was a signalling function. They signaled the source, the authentic source of the TMK good, the person with whom to deal, if you wish to buy the medicine or get a license to make it, or indeed acquire the patent from the patentee. So in all likelihood, the patent here, which discloses a preparation and which is made from these ingredients listed, probably doesn't list all the ingredients you need. So in conclusion, what are my conclusions? Well, one, my conclusion is there's good evidence that, at least amongst TMK practitioners, that commodity orientation or marketisation is associated with patent grip. Two, formal education is also important, and income is also important for explaining patent grip. Three, through participation in markets, TMK practitioners become more predisposed towards viewing traditional medicines as commodities, and then the strategy of using patents to protect them, those traditional medicines, becomes more obvious. However, the patent strategies adopted by TMK practitioners reflect a syncretization between customary practices and the dictates of patent law. What I'm suggesting is that if we want to understand China's patenting phenomenon, we've also got to consider the extent to which people are commodity exchange oriented or are marketised in order to really, together with the other factors that we went through earlier, in order to explain the patenting phenomenon. So one final word. As it has turned out, not only does the patent system help towards the end of exchange of commodities, as Director Huang Kunyi put it when China's patent law first came into effect in 1985, but perhaps and more importantly, the exchange of commodities helps towards the ends of the patenting system. Thank you for your time.
Thank you. Thank you very much. Now we have a few moments for questions, and yeah, Andrew's hand is straight up. You have to be quick, so please.
Thanks very much. They're very interesting. Is it the case that TMK tends to be held more by the minority groups than by the mainstream, or was that just the focus of your research?
It was just the focus of my research. So you have traditional Chinese medicine held by the ethnic majority Han, and indeed a very strong focus from the government to push and promote people selling it, and a very guarded response. So I did also try to speak to some traditional medicine companies, but they were very guarded. They thought that I might want to take their traditional medicine secrets and exploit them, even though I made clear I don't want to know what the traditional medicines are. I have no need to know that for the purposes of my research. I just need to know about attitudes to patenting and marketisation.
The reason why you focused on the meow then, was it the location, the geographical?
The market had developed. So I think, I can't remember the first, maybe 2005, 2006, 2007 was the first meow medicine patent I could find. And then the market was really being pushed since about the late 2000s into the, so when I was looking at this case study, it would have been about 2016, 2017. So it really seemed to be quite a new market to me then, specific, it's quite a, the meow traditional medicine is quite famous in China. It's recognized. So there's a real push and a real development of a market for it.
Any other questions or comments or suggestions for the?
Now, I'm quite interested in your research and especially the field research. I actually personally am not very interested in traditional medicine patents because as far as I know, we actually don't have that many patents in terms of traditional Chinese medicine. But do you know how many patents are made based on meow medicine, and who are the patentees? Because I noticed that the picture I asked about the company, the green, the blue, the green one, the orange one is about companies, pharmaceutical companies active in Guizhou. So how many patents are owned by private companies, state-owned?
Oh, I didn't. I mean, that would be fascinating research. I didn't look at that. Yeah, I've got a, but I can't. Can I go back? Oh, there we go. Now I've got control again.
You don't have control.
Don't have control. Okay.
Yeah, that's the one.
All right, that's the one I wanted. Yeah.
Maybe one.
No, this is the.
Oh, but you're asking about traditional medicine
This is
patents
traditional medicine.
and how many would be owned. So if you go to the patent database, you can work out. So I could get a pretty good idea of how many meow medicine patents there are, generally by doing a keyword search. And then, I mean, if I were a more fluent Chinese speaker, maybe I could be more sophisticated, but I used the character meow and then read through all the patents. Meow is also a character used in the word for vaccine, so I had to exclude those and just try and get the meow medicine patent. So I don't remember off the top of my head how many I counted, although I did do that count. I don't think they list the ethnicity of the person applying for the patent, but the reason I could get the number in Guizhou is that there's a code for each province. So I could search for traditional medicine patents that had been applied for from people whose address or whose patent agent's address was Guizhou. So that's how I could get that. I didn't do a study, although it would be a really interesting and good study to look at as to whether or not, as to who's applying in terms of, are they private entities, are they individuals, are they state-owned entities, are they collectively owned entities applying for traditional medicine patents? I didn't do that analysis.
Good question. So if to protect commercial information, you can opt for trade secrets and/or patents. Is that not the same for China?
You do, yeah. So you can, and the traditional view with trade secret law and patents is you've got a binary choice. So it's like either you go down the trade secret route, or you go down the patenting route. So China also, under its unfair competition law, gives protection for trade secrets. But I think what we're seeing here is there's a challenge to that orthodoxy around, it's a binary choice between protecting using trade secrets and protecting using patent law for various reasons. Like you might decide, well, a patent's too expensive, whereas trade secret protection, I don't need to. It's not a registered right. I don't need to register a right, as your comment suggests. You already know. I can just keep it secret, and then if someone tries to take that secret away, I can stop them. I can get an injunction against them, or I can get damages at least from them if they've already Charles Barkley likes to say, spilled the toothpaste out of the tube. You can't get it back in. But what we see happening, at least with the people I spoke to, is there's kind of an interesting trying to have your cake and eat it too, in terms of I get the patent protection, that will give me certain kudos, certain sort of marker, certain imprimatur of state approval, and also give me some protection, and will signal to the market, I'm the one you've got to come to if you want to buy, make, or become the maker of this medicine. But also a reliance on secrecy, by not revealing everything about the formula.
Hi, so I'm starting my JD next year, and I've just transferred from being a teacher, so I don't know much about patent law yet. I was wondering, out of all the participants that you spoke to, were any of them have any of them, or do any of them plan on actually getting their like ancestral formulas patented, or were anyone inspired by your research to go?
Well, I mean, that's an interesting ethical question about the influence of the researcher in the field. I hope I didn't affect them one way or the other, in terms of, you know, obviously you want to try and remain neutral as a researcher. You can't, obviously, it's not possible. I don't think they would have been inspired by talking to me to get a patent. You know, they had pretty strong views one way or the other when I asked them. Some of them didn't know what a patent system was, so I'd explain to them, well, this is what a patent will do, and they'd either say, oh, that sounds like a great idea. Generally, those people would say, that sounds like a terrible idea. It should either be, you know, you have to keep it secret, or there'd be not enough trust in the government to disclose it to the government, or yeah, I don't say that. Yeah, I'm not sure I've answered your question, but there were varying views about whether or not they'd want to get a patent or not get a patent, and I like to think it wasn't influenced by my questions of them.
Thank you for sharing your years of work with us in this concise lecture. I've been pretty inspired. When I was about to leave for school in America when I was 18, I fractured my toe, and when I went to the Western hospital, they said you have to put on a cast. But I wasn't going to do that because I was 18 and I was ready to do my university life. So my father took me to his friend who has a ancestral chiropractic. He also has a secret little spray.
One of the areas of medicine that Meow medicine is famous for is healing bone fractures, because they're in the mountains. People probably a lot of history of injuries, so quite a few of the ancestral formulas there are sprays and lotions, or for just that type of injury.
Yeah, I think like with your work and promoting knowledge of patent law, maybe some of these formulas will get passed down instead of dying with a certain generation.
Again, I wasn't promoting patent law. I was a neutral observer in the field. Well, to the extent I could be. Yeah.
Did you have a follow-up question? Yeah, I was just going to ask, given your research, do you think that the locals would be more or less likely to support the idea of compulsive licensing in pharmaceuticals?
Oh, no, I didn't ask them about compulsory licensing.
No application for compulsory licensing.
Oh, okay.
Zero applications?
Yeah, that's true.
Yeah, so there's, as I said before, there's provision still within the patent law for compulsory licensing, but it's very diluted in terms of state control and state ability to control and use and license patented inventions. It's very diluted during today's law with the 1984 law.
So tell me, is one of the sort of important theoretical findings of your thesis that you sort of reverse the causation, in that it's sort of marketisation which actually makes people sensitive to or receptive to patents, rather than the patent law itself aiding marketisation or that?
Yeah, exactly. I don't think I could put it better myself. Yeah, that's exactly one of my key claims. Yeah.
Generally, that it's the
It's the market that drives the
Drives
property,
property.
not the property that is.
Yeah.
Yes. Absolutely.
And I think one of the things that Ben hinted at, that is probably understated, is the importance of getting to the level of the individual. Whereas most of the economics literature sort of stays at aggregate levels and looks at firms and looks at what people do, and then seeks to sort of deduce from that about what people think. And then when you looked at what people actually think, you actually find something quite different.
Yeah.
Which is I know you said it doesn't blow up the economics literature, but in my mind, it certainly adds an important dimension.
I hope so, anyway.
Yes.
Yeah.
Were there any other final sort of comments or questions or interventions? One more?
Yeah.
Okay.
Do you know, in China, we actually have a so-called 中央品种权. You know that? No. It's, yeah, very, I mean,
Country government, what things?
yeah, it's an actually, variety right.
Oh, right.
So yes, he does know it.
Yeah, sorry. Yep.
Only for Chinese,
Medicine.
medicine.
Yes, sorry, I do know.
Variety is different. It's actually administrative privilege.
To protect traditional medicines, you mean?
Sorry?
To protecting traditional medicines? Yeah. No, I know that. That's like a state protection.
Yeah, only for some so-called qualified companies. Only particular company or companies which can get the license from the government to produce a particular Chinese medicine manufactured.
Oh, right. Okay. Yeah. I mean, I do know there's, and I didn't go into it in today's talk, there's specific sort of sui generis protection for traditional medicines where you effectively register the secret with the state. It's not published more widely. It's just the state has it, and that can last for between 15 and 30 years, and the state sort of supports you in being the only person who can make that traditional medicine. I didn't look at that too much. I'm not sure it's that widely used, but I could be wrong. People tend to go for the patents over that.
Because Ben was looking at individuals, not companies.
Yeah.
Also, yeah. Companies wouldn't speak to me.
Different subject. That's right. Now, unfortunately, I have failed in my task of stopping this seminar on time. But that's because the seminar has been so fascinating and really great questions, thoughtful questions and answers. And I hope that you keep on with this work, and I'm waiting for you to organise a study tour so that I can go and deal with all of, my arthritis and things like that.
Sure.
Go down into the mountains and find a cure.
Yeah, we can. Visit the various practitioners. Hopefully I can find them again.
Yes, it's true. But look, I think you'll agree with me that this work is a massive and long-term piece of work. And it's innovative. It's really important. I think for its details, but also for how we think about patent and its relationship to the market. And I thank them very much for coming to talk to us today about this work. Thank you.
Thank you, Sarah.